In what may become one of the biggest child molesting cases ever on record, 7 nursery school teachers were arraigned today on more than 100 counts of child molestation.
The accused include the preschool owner, 76-year-old Virginia McMartin, her daughter, and 2 grandchildren.
The McMartin preschool case, a highly publicized controversy, involved numerous allegations of child sexual abuse against the school staff, which later proved unsubstantiated. Damaged by biased interviewing and public hysteria, the trial severely jeopardized the defendant's right to a fair and speedy trial, promised by the Sixth Amendment. This case highlights the responsibility of investigators to conduct objective investigations and the responsibility of the public to engage in careful media consumption. On August 12, 1983, Judy Johnson reported to the police that her 2-year-old son, Billy Johnson, had been sexually molested by his preschool teacher, Raymond Buckey. Earlier, she had gone to the doctor on her son's complaint that his anus had itched, having trouble sleeping and sitting down. 6 days later, she reported with Detective Jane Hogue on the complaint that Ray Buckey sexually abused her son. 2 days later, she took her son to the police station for an interview, where he reported Mr. Buckey had been abusing him. She claims that she had spotted a drop of blood on Billy's bottom one day after school. The doctors believed Billy had been sodomized. Mr. Buckey was arrested on September 7, 1983, but was released the same day due to a lack of evidence. The following day, police sent a letter to 200 McMartin preschool parents, informing parents about a criminal investigation involving child molestation allegations against Ray Buckey. The letter encourages parents to ask their children about sodomy, oral sex, and fondling.
And pretty soon, emotionally involved parents are engaging in leading and suggestive questioning of their child.
Virginia McMartin founded the McMartin Preschool, creating a happy and loving environment within the Manhattan Beach community. Under her guidance, the school flourished for decades, transitioning to her daughter, Peggy Buckey, and was assisted by her 2 grandchildren, Ray Buckey and Peggy Ann Buckey. Their seemingly idyllic lives would forever be changed on Friday, August 12, 1983.
Ms. Johnson reported to the police that Billy had told her Ray had sodomized him while his head was in the toilet. She continued to make clear claims that Buckey wore costumes such as Santa Claus and as a minister. Once taking Billy to a car, washed him and locked him up in a trunk. Allegedly, Ms. Johnson claimed that Billy had told her the teachers at the preschool had chopped up rabbits and placed them on Billy's bottom. On October 17, 1983, the District Attorney's Office asked consultant Kay McFarlane, the Children's Institute International, to interview the children who attended the preschool. The CII interviewed nearly 400 students, diagnosing some of them as having been sexually abused. The McMartin Preschool officially closed on the 13th of January 1984. A multitude of other preschool and daycare centers all around the United States were accused of sexually abusing children, ritualized abuse, and satanic practices during the 1980s.
Los Angeles District Attorney Robert Philibosian is prompted by public unrest to send the case to grand jurors who indicted Raymond Buckey, his mother Peggy Buckey, his sister Peggy Ann Buckey, and his grandmother Virginia McMartin, including other preschool teachers Mary Ann Jackson, Betty Rader, and Babette Spittler, on 115 charges of child molestation. 2 days later, all 7 defendants were arrested and jailed. Ray Buckey is held without bail.
My son didn't do anything, nor my mother, my daughter, or any of the teachers. And I just can't.
The preliminary hearing began on August 1984. 14 children testified that they were molested and forced to play naked games and participate in satanic rituals. They claimed that some defendants had touched them on their genitals. By March, led by Bob Curry, a group of McMartin preschool parents began to dig for alleged secret underground rooms on a lot near the school in which they believed widespread sexual abuse occurred. Neither this search nor a subsequent search by an archaeological firm hired by the district attorney's office found any evidence to support these claims. District Attorney Ira Rayner dismisses charges against 5 of the defendants, stating that the evidence against them is sufficiently weak. Ray Buckey and his mother, Peggy Buckey, continue to face 99 counts of molestation and 1 count of conspiracy. The Buckeys begin their first trial on 79 counts of child molestation. Buckey was released on bail in February 1989 on a reduction from $3 million to $1.5 million after spending 5 years in jail. The first McMartin trial ended on January 18, 1920. The jury found the Buckeys not guilty on 52 counts. The jury deadlocked on 12 molestation charges against Ray Buckey and on 1 count of conspiracy against the 2. The judge declared a mistrial but later dismissed the conspiracy charge faced by Peggy Buckey. Peggy Buckey is acquitted while the jury hangs on the 13 counts against Ray Buckey. Due to the immense parental pressure, the prosecutor, Ira Rayner, announces a second trial on 8 of the deadlock counts regarding Ray Buckey. On July 27, 1990, the second trial of Ray Buckey ended with another deadlocked jury. Rayner does not ask for a second trial. After 7 years and $15 million, the McMartin preschool case is brought to an end. The preschool is demolished in the following year.
The McMartin preschool case is a perfect example of mass hysteria. It highlights the dangers of suggestive questioning in child abuse investigations. Most of the allegations were made at Children's Institute International, or the CII, a child abuse prevention center.
To encourage the children to reveal what happened, the therapists were able to unlock the horrible...
The rigid investigative techniques raised serious concerns about reliability of the children's testimonies and the clear potential to elicit false confessions. There have been many studies that examine the influence of a single misleading suggestion on children's recall of an event. The CII interviewers would question the children in such a way that they would get their desired answer through leading questions, praising the children when they answered in the way the interviewer wanted. This encourages the children to give misleading testimonies, using pressure to create preferable answers and repeating questions until the child creates a false memory or distorts their existing ones. A direct examination conducted by Lael Rubin and cross-examination by Dean Getz and Daniel Davis, August 3 to 6, 1987, of a 12-year-old girl witness in regards to the trial highlights the suggestive language such as leading questions and repetition. Rubin's direct examination demonstrates potential for suggestive questioning techniques with leading questions that assume the child's actions or actions the child had witnessed, which he used repeatedly. The child had initially stated, "I told you I didn't know anything," when asked by Ms. Shawn from CII about what happened at the preschool, which contradicts her later testimony where she described being touched by Ray and Peggy. The child's testimony during the examination was riddled with inconsistencies, influenced by outside factors, molded by extensive preparations with attorneys, and was guided into providing smart answers, meaning answers more favorable by the attorney. The McMartin preschool case severely compromised the defendant's right to a fair and speedy trial. Flaws in the investigative process, including irresponsible child interviewing techniques and a lack of objective investigations combined with public hysteria, resulted in prolonged and inconclusive legal battles, subjecting the defendants to years of unwarranted incarceration.
On the other hand, cases like these involving severe child abuse allegations require more extensive and rigorous investigations, regardless if they result in lengthy legal proceedings. The possibility of injustice in any legal proceeding exists and needs to be acknowledged, but the safety and well-being of children in these types of allegations are also to be acknowledged.
So there's a very clear protocol about how to interview kids, and
these cases, despite their challenges, can contribute to a better understanding of child abuse cases.
The investigative techniques were biased and subjective, heavily influencing the allegedly sexually abused children. It is the responsibility of not only the CII investigators, but of all investigators in all cases and fields of law to maintain objectivity in the court and to preserve the rights of all parties to a case. The public is also accountable for how they engage with this type of information. It is important to think critically and to exercise independent judgment